All right, we are on record in cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Attorneys for the state, attorney for the defendant, and the defendant are present on the witness stand at this time is Ms. Sheila Prater. Yesterday, it came to the court's attention that there would possibly be some questions asked by Mr. Stevens regarding potentially incriminating responses, depending on the response of Ms. Prater. And it was recommended by Mr. Stevens that the court consider whether or not Ms. Prater should be afforded the assistance of counsel. The court had reviewed her indigency and finds her to be indigent. The court has appointed the Honorable Richard Schmidt for the limited purpose of advising Ms. Prater regarding her questions or regarding the questions and her answers thereto in this trial. Mr. Schmidt, at this time, if you will just, without divulging attorney-client privilege, can you just assure the court of any admonishments or statements of representation that you've made to Ms. Prater so that the court is satisfied that she understands her rights and her Fifth Amendment constitutional right against self-incrimination?
Yes, sir. After a brief review of the indictment in this case and the applicable statutes, I informed Ms. Prater of the statute of limitations as far as state charges are concerned, statute of limitations pertaining to any federal charges that might arise against conduct, no right to remain silent, and against self-incrimination. How that works as a witness, as well as the potential consequences for aggravated perjury, which is making a material misstatement under oath, and those potential state consequences of her right to either waive those rights or to assert them during her testimony.
Thank you, Mr. Schmidt. And so, Ms. Prater, you understand that I swore you in to tell the truth yesterday, and so now you're under oath just like you were yesterday. You understand that?
Yes.
And you've had the opportunity to talk with Mr. Schmidt, who the court has appointed as your attorney, correct?
Yes.
Do you understand that you have a right against self-incrimination?
Yes.
Do you understand that any questions asked by either the defense, through Mr. Stevens, or through the state, through either of their prosecuting attorneys, that if that question has a tendency to potentially incriminate you regarding the response, you understand that you have a constitutional right to not answer that?
Yes.
And are you comfortable with what your discussions with Mr. Schmidt have been regarding what your rights are and the potential criminal consequences should you waive any of those rights or make any kind of statements that is incriminating to you?
Yes, thank you.
Okay, and so I'm going to go forward and I'm going to allow Mr. Stevens to ask us questions, and when he's through asking you questions, you'll be passed over to the prosecutors and they'll be able to ask their questions. If during that time you feel like you need to speak with Mr. Schmidt regarding any answer that you may give to that question, what I would like for you to do is just turn and look at me and say, Judge, I would like to speak with Mr. Schmidt.
Okay.
And then we'll pause briefly. We may not excuse the jury, but I may allow Mr. Schmidt to walk up here and be able to have a conversation with him, and he can advise you during your question.
Thank you.
Okay?
Yes.
Mr. Schmidt, any objection to that procedure?
No objection to that procedure, although I would remind you that if you do speak with me, do it before you answer the question.
Yes.
All right. Any issue from the defense?
No, sir.
Any issues from the state?
No, sir.
Okay, we ready to bring the jury in?
Yes.
All right. Let's all rise for the jury. Hey, you may be seated. All right, good morning, ladies and gentlemen of the jury. I appreciate you being here on time this morning. We are back on record in cause number CR 21-98. The jury is present and seated in the courtroom, along with the attorneys for the state, attorney for the defendant, and the defendant. I believe, ladies and gentlemen, that when we left off yesterday, I told you that we had some legal issues I needed to accomplish. We were able to get those done in your absence. And so we're going to resume with the testimony of Ms. Sheila Prater this morning. And I believe, Mr. Stevens, you had Ms. Prater on direct examination. Is that correct?
Correct, Your Honor.
All right, you may proceed at this time.
Thank you, Your Honor. Please state your name for the record and spell your last name.
Sheila Diane Prater. Prater is Prater.
All righty. And ma'am, how do you know Mr. Young?
Ray is my son.
Okay. And do y'all live together?
No,
Did y'all live together back in November of 2020?
no.
Okay. Were you back in November of 2020? Do you recall where you were?
I was in Arizona.
Okay. And what was the purpose of being in Arizona?
I had had my knees replaced and I had gone back to Arizona
Okay.
for the doctor and I was actually like living there. So
Okay. And when you were not in Arizona, but when you're back here in Texas, where do you live?
excuse me.
Where do you live in Texas here?
In Ben Wheeler.
Ben Wheeler.
Yes.
Okay. And what kind of building or structure do you live in?
I live in a travel trailer.
Travel trailer.
Yes.
Okay. And how long have you lived in that travel trailer?
I bought it about 8 years, 8, not well, probably longer than that now.
Okay.
In what, 2011, I think.
Okay. Does anybody live with you?
No,
Okay. You live by yourself?
yes,
Do you have any animals or pets?
me and my babies. I got fur babies.
Okay. And when you were out of town, was your son going over to your property, taking care of the animals and whatnot?
Yes,
Okay. As far as you know, was he staying on the property, living on the property?
not that I knew of, no,
Okay. He had his own residence, did he not?
yes,
Do you recall if that was in Athens or not?
it was in Athens.
Okay. Now, do you know somebody by the name of Larry Don?
Tommy Don,
Tommy Don, I apologize.
yes, Tommy
You know
Don.
Tommy Don?
I do.
Okay. And how do you know Tommy Don?
Tommy Don is a neighborhood guy that, he's a jack of all trades.
Okay.
And so everybody knows Tommy Don.
Okay. And Tommy John was actually arrested around your property. Is that correct?
Correct.
Okay. And after Tommy Don was arrested, okay, he had some property that he was worried about being stolen from his residence. Is that correct?
Yes.
Okay. And what was some of the property that he was worried about?
He had a TV and he had a gun,
Okay.
antique gun.
Okay. Was that a shotgun? Do you remember if it was a shotgun?
Yes, it's a shotgun.
Okay. And did you take possession of those items to keep for him while he was locked up?
Yes, I did.
Did you go to his property and get those items, or did your son bring those items to you?
I went to the property and picked them up.
Okay. And do you know if after you picked up the property, what did you do with it?
The TV is in the living room behind the chair. And I put the gun in the freezer. The
Okay.
freezer in my travel trailer does not work. So I just stuck it up there.
Okay. And where was the freezer located within your residence?
It's in the travel trailer. But like I said, it does not work. It's like just on the west wall.
Okay, but it's inside the tractor
Yes.
trailer.
Yes.
Did you ever ask your son to pick up the guns, handle the guns, bring them to you or anything like that?
No,
Okay. And so you're telling this jury that you're the one that picked up the shotgun and the TV and took to your property.
that's what I'm saying.
And do you know any idea about how long you'd had that shotgun?
Tom John was doing some work for me, and I think he started doing that around September.
Ma'am,
As
would that be
best as I can remember.
September of 2020?
Right, as
Okay.
best as I can remember, it was late August. I'm thinking it was late August, early September. And this incident happened in November.
Right.
So like what, 3, 4 months,
Okay.
somewhere like that.
What kind of work was he doing on your property?
He was tearing down my grandparents' house.
Okay.
And so,
And were you there when the police came to arrest him?
I was.
Okay. Did he ask you to get that property?
Your Honor, objection leading.
Sustained.
Did Tommy Don ask you to go get that property?
Objection leading.
Over,
Judges.
over,
Calls for hearsay.
hearsay?
Yes.
Sustained.
You did not go get that property at the direction of your son, did you?
No.
Okay.
No.
Do you know if your son ever handled that shotgun or not?
Not that I know of.
Okay. All right. I'll pass the witness, Your Honor.
Mr. Hernandez, your witness.
Thank you, Your Honor. Good morning, Ms. Prater.
Good morning.
Let's just start there. The question that counsel just asked you was if you knew if your son ever handled that gun. Is that the shotgun you're talking about?
Is okay. Okay. I'm not exactly sure what you're asking me.
Okay, let me clarify. I appreciate you asking me to do that. You just answered the question, did your son ever handle that gun? And you said no. Which gun are you referring to?
We're talking about the gun that's in question, correct?
Well, that's what I want to know. Which gun are you referring to?
How many guns are we talking about? I'm confused. I apologize, but
Let me ask you about the shotgun.
okay, ask me about the shotgun.
Okay, the sawed-off shotgun.
Yes,
Okay. Counsel just asked you if you knew if he ever handled it, and you said, not that I know of.
no,
Is your answer now no, or is it not that you know of?
not, I cannot say what someone did, not that I know of.
Okay,
Yes, that's my answer.
so he could have handled that weapon and you would not have been aware of that. True?
I can't see people when I'm not there, so
Exactly.
that's correct.
Okay. So if there had been testimony here where, well, let's back up. Do you see your son here in the courtroom today?
Yeah, I do.
Okay, and can you just tell the court where he's seated?
He's sitting right there.
All right, so you see him. That's Ray, I believe you spoke with. You mentioned Ray.
I call him Ray.
Okay, but he goes by Reginald. Is that his first name?
His first name is Reginald.
Okay,
I call him Ray.
okay. So let's get into the piece about the weapon. You were confused as to which gun we were talking about.
Well,
How many guns did you have on that property?
well, I mean, you're the one that said which gun. So like, I'm trying to like, is there any other gun that we're talking about that I don't know about? Because I only know about the one gun.
Your Honor, may I approach the witness?
You may.
Yes.
Spraker, this has been identified as State's Exhibit 7. Do you recognize this weapon?
I ain't never seen that in my life.
Never seen it in your life? Okay.
No.
And if,
Whose is it?
well, if your son testified that he shot this gun while living on your property, was he lying?
Sir, I don't know what gun, I don't even know anything about that gun.
You don't.
I'm sorry.
Okay. Well, if I were to tell you that there's been testimony that your son told law enforcement that he asked you, or he went out and picked up a sawed-off shotgun and the rifle and brought it back to your property, is that a lie?
Sir, I don't know anything about that gun.
So you don't know if he shot it or not.
Sir, I don't know. I don't have a clue. I don't know anything about that gun.
So he could have shot it then.
Sir, anything can happen. I don't know anything about that gun.
Okay.
Now, this gun I know about.
Can we talk about your property there, ma'am,
If you like,
please? How many mobile home or travel trailers are on that property?
2,
2.
yes.
Okay. And how would you describe the one you live in?
It's a 5th wheel. Got a bedroom, kitchen, living room.
Okay. All right. And what about that second? Is it more of an RV or is it a
No,
trailer?
the other one, was my mom's.
Okay.
So it was a double wide,
Okay, double wide. All right.
yes.
And do you know Tommy Don's last name,
I
ma'am?
do not.
You don't. Okay. Waddell, does that sound familiar?
I don't know.
Okay. All right. So this morning you testified that you actually moved that sawed-off shotgun. If I may approach, Your Honor?
You may.
You testified that you moved this sawed-off shotgun
Yes, sir.
and placed it in
The freezer.
the freezer.
Yes, sir.
And where was that freezer located again?
In my RV.
In your RV. And you
Yes.
testified that that RV, that it was in the freezer and that freezer was inside your RV.
Yes.
All right. I'm showing you what's been marked as State's Exhibit 1. Do you recognize that, ma'am?
Yeah.
What is that?
This is refrigerator, and this was an outside freezer.
Outside freezer.
Yeah,
Okay. And where's that freezer located on your property?
it's in the back.
Okay. And it looks to be that there's a trailer or a mobile home behind it. What is that?
Yes,
Is that the one you lived in?
yes,
So there's a refrigerator to the right and then the freezer is center on State's Exhibit 1. Is that correct?
right.
And you've testified that when you moved that sawed-off shotgun, you put it inside the freezer in your RV.
Yes.
And that freezer is not in your RV in State's Exhibit 1, is it?
No, it's not.
Okay. So if your son had told law enforcement that he moved that shotgun and that rifle from an automobile and put the shotgun, the sawed-off shotgun, in that freezer, is he telling the truth or is he lying?
So I don't know.
You weren't there all the time, 100% of the time.
No, I
Fair.
was not.
Okay. I may approach, Your Honor.
Yes, sir. You may.
Ms. Prater, I'm showing you now a photograph that's been identified as State's Exhibit 3.
Okay,
Do you recognize that?
yes,
What is it?
freezer,
That's the freezer.
yeah,
How about State's Exhibit 4 and 5? What is that?
that's that gun you just showed me.
And where is that located?
It's on the bench
And where is that bench located?
in the house,
Which house?
in mine,
That's your house.
yeah.
I have no further questions, Your Honor. Ask the witness.
Mr. Stevens, you're with us.
Yes, Your Honor. Ms. Prater, when you picked up the shotgun to put it at your property for safekeeping, did you
Yes.
know that it was an illegal prohibited weapon?
Had no idea,
Have you ever shot a gun?
no.
Never shot a gun.
City girl,
So you're not familiar with firearms at all.
not at all,
It's your testimony that you are the one that picked up the shotgun and put it in on your property, correct?
yes,
Pass witness, Your Honor.
Mr. Hernandez.
Ms. Prater, you weren't home on November 25th, 2020, were you?
no, sir, I wasn't.
And where were you on that date?
I was in Phoenix,
Pardon me?
Phoenix, Arizona.
Phoenix, Arizona. Okay. When did that surgery take place?
Oh, I had several. So starting in 19 to 20,
But November 25th, you were in Phoenix.
yes,
And your son, the defendant, was taking care of your property that day, was he not?
yes,
And did you know who he was dating back then on November 25th, 2020?
Heather,
Heather. And to your knowledge, was Heather there that day as well?
I have no idea.
You don't know. Okay.
But if Ray was there, I would assume so, but I
Okay.
wasn't there, so I don't know.
Okay. So you weren't there, and I just showed you State's Exhibits 4 and 5 showing that rifle. And it's inside your RV, is it not?
Yeah,
And you were in Phoenix, so you have no idea how that would have been put inside that
no,
RV. And it's your testimony that that shotgun was placed in the refrigerator inside your RV.
that's where I put it.
So the freezer that I showed you in State's Exhibit 4, that's not the one you're talking about, is it?
No, it's not.
So logically, it would make sense that somebody pulled it out of your refrigerator and put it outside in the freezer.
Logically speaking, I mean, hey, we can't go against logic. It didn't walk out there. So, yeah, somebody had to take it.
No further questions, Your Honor. I pass the witness.
Mr. Stevens,
No further questions, Your Honor.
any objection to Ms. Prater being finally excused?
No, Your Honor.
No, Your Honor.
All right, Ms. Prater, you're free to go. Watch your step. Ms. Prater, you're free to stay in the courtroom if you want to, or leave, whatever you want to do. Thank you, Mr. Mr. Stevens, does the defense call any additional witnesses?
No, Your Honor, the defense will test it.
Defense does. Any rebuttal by the state?
No, Your Honor. The state rests and closes.
Closes, defense closed.
And close, Your Honor.
All right, thank you. All right, ladies and gentlemen, you have received all of the evidence in this case. However, you've not received the court's written instructions, nor have you received the closing arguments of counsel. So what I'm going to do is put you in a recess for about 30 minutes, give me an opportunity to speak with the attorneys, give them an opportunity to be heard on what instructions they want to hear. And so it's going to take a little bit of time. I think 30 minutes will be sufficient. It's a quarter till 10 approximately. So I'm going to ask that you just be back in the jury room no later than 10:15. All right. Remember, you're not to discuss the case with each other or anyone else. If anyone tries to talk amongst you all about the case or to talk to you about the case, you report it to the court immediately to the bailiff. Okay. All right. All rise for the jury. All right. Are there any issues before we recess to do the charge conference?
No, sir.
Okay.
They're
All
not
right. Give me just a few moments and let me print out the proposed charge that I have, and then we'll meet back in my chambers and kind of go over it together. Okay. All right. Court is in recess at this
I
time.
have a question. Do you want to send the evidence back, the guns, or do you want me to take a picture to submit the picture?
The guns have been made safe, correct?
They have been, Your Honor, yes.
Let me think about that. I'll tell you when. All right, we are back on record. Cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury, attorneys for the state, attorney for the defendant are all present. The court has conducted its charge conference with counsel, giving them an opportunity to review the court's proposed jury instructions. On behalf of the state, are there any objections to the court's proposed jury instructions?
None from the state, Your Honor. Thank you.
Thank you, Mr. Hartwell. Mr. Stevens, on behalf of the defense, any
No
objections?
objections, Your Honor.
All right, there being no objections, then the court will submit the jury instructions to the jury. Any other issues before we bring the jury back in?
No, sir.
No, sir.
All right, then the court will grant each side 20 minutes for closing arguments. And I understand the state will be dividing theirs 6 minutes for opening and 14 for the closing. Okay. All right. All right, then let's all rise for the. Be seated. All right, let the record reflect that the jury is now present and seated in the courtroom. All right, ladies and gentlemen, at this time, I'm going to read the charge of the court containing the law applicable to this case and continuing to discharge your responsibility as jurors. You will continue to observe all the instructions that have previously been given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, the parties, the attorneys, and myself. If it should be found that you have disregarded any of these instructions, it will be jury misconduct and it may require another trial by another jury. If any of you observe one or more of your number violating any of these instructions, you shall immediately warn the violator and caution him or her not to do so again. Please listen carefully as I read the charge to you. And a copy has been provided to you for your reference. Jury instructions. Members of the jury. The defendant, Reginald Hoyt Young II, is accused of the offense of possessing a prohibited weapon. You have received all the evidence and must now decide whether the defendant has been proved guilty of an offense. Both sides will soon present final arguments. Before they do, I must now give you the instructions that you have to follow in deciding whether the defendant has been proved guilty of an offense or not. You will have a written copy of these instructions to take with you and use during your deliberations. First, I will tell you about some general principles of law that must govern your decision of the case. Then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. Indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all, unless all jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. Jury as fact finder. As the jurors, you review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by attorneys during the trial are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of the testimony of the witnesses and materials admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may examine exhibits if you wish. Only exhibits that were admitted into evidence may be given to you for examination. In order to inspect the weapons admitted into evidence, you must submit a request in writing to the court. Testimony. Certain testimony will be read back to you by the court reporter if you request. A request must follow these rules. The court will allow testimony to be read back to the jury only if the jury, in writing, signed by the foreperson, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The verdict. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty means that the state's evidence does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. Defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Specific law applicable to this case: accusation. The state accuses the defendant of having committed the offense of possessing a prohibited weapon. Specifically, the accusation is that the defendant did intentionally or knowingly possess a short barrel firearm, an Eastern armed 16-gauge shotgun. Applicable law. A person commits an offense if the person intentionally or knowingly possesses a short barrel firearm. To prove that the defendant is guilty of possessing a short barrel firearm, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, the defendant possessed a short barrel firearm, and 2, the defendant did this intentionally or knowingly. The state must prove beyond a reasonable doubt the accusation of possessing a prohibited weapon. Definitions: possession. Possession means actual care, custody, control, or management. Intentionally. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. Knowingly. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Firearm. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by this chapter, and that is an antique or curio firearm manufactured before 1899, or B, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or center fire ammunition. Short barrel firearm. Short barrel firearm means a rifle with a barrel length of less than 16 inches or a shotgun with a barrel length of less than 18 inches or any weapon made from a shotgun or rifle if, as altered, it has an overall length of less than 26 inches. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt 2 elements. The elements are that 1, the defendant in Van Zandt County, Texas, on or about November 25th, 2020, possessed a short barrel firearm, and 2, the defendant did this intentionally or knowingly. You must all agree on elements 1 and 2 listed above. If you all agree the state has proved beyond a reasonable doubt each of the 2 elements listed above, you must find the defendant guilty of possessing a prohibited weapon as charged in the indictment. If you all agree the state has failed to prove beyond a reasonable doubt elements 1 or 2 listed above, you must find the defendant not guilty of possessing a prohibited weapon as charged in the indictment. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this trial with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the court only in writing, signed by the foreperson and given to the court through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must inform the court if anyone attempts to contact you about the case before you reach your verdict. 6, you have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during your deliberations. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the attorneys. Notes are valuable as a stimulant to your memory. On the other hand, you might make an error in observing, or you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade the fellow jurors of what the evidence was during trial. Your sole duty at this point is to determine whether the defendant has been proved guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Next page, verdict form. Not guilty. We, the jury, find the defendant, Reginald Hoyt Young II, not guilty of possessing a prohibited weapon as charged in the indictment. Or guilty, we, the jury, find the defendant, Reginald Hoyt Young II, guilty of possessing a prohibited weapon as charged in the indictment. The court's original instructions will be provided to you by the bailiff in this notebook here. Also within this notebook, you will find forms entitled Jury's Communication to the Court. This is how you would communicate to the court in writing. It requires you to write the case number, which are found, it's found on the court's instructions, date, time, and which communication, 1, 2, 3, etc. And it also must be signed by the presiding juror with a signature and also a printed name. And it should be complete, and it should be thorough and fully convey if there is a question or an issue. Okay. All right. At this time, the state will be permitted to give the first closing statement. Mr. Hernandez, are you
Yes.
doing that?
Yes, Your
All
Honor.
right, you may proceed, sir.
Thank you very much.
Do you need the podium, sir?
No, sir, I do not. Thank you. Okay, please, the court, Mr. Stevens. Thank you very much, ladies and gentlemen, for your attention to this matter. This is the last time we'll get to address you directly, and then you'll be given the opportunity to go into deliberations, go through the evidence. I'd like to start off by pointing out in the instructions on page 5, possession. Possession means actual care, custody, control, or management. I'd like to point out possession for you. I'm now possessing it, caring for it. It's under my control, under my management. I'm still possessing it, right? That was 6 steps that it took. I knew it was there. Possession. That is an Eastern Arms 16 gauge shotgun. As ATF agent Petrie testified, it's a rather old shotgun, but its posts 1890s. He says it's probably early 1900s. So the exceptions as a curio or as a relic don't apply. This is a prohibited weapon by all accounts and definitions and should not be in public. He told you the very reason for it, or at least one of the considerations was it's something that can be used for a lot of people. Placed underneath a trench coat, placed inside a coat. There are reasons for that. Also, got into specifics, the definition of that. You recall, it needs to be a barrel length less than 18 inches. Investigator Keltner testified that barrel length was 11 inches. That means somebody took off at least 7 inches off that barrel, making it an illegal weapon. And by all accounts, the full length, Investigator Keltner testified, was 19.5 inches. At a minimum, it should be 26. There are very good reasons in history why those things shouldn't be out. You've heard during the testimony that in conversation with Agent Petrie and Investigator Keltner, admitted by his own words to going over to Mr. Waddell's property to get those two firearms, get the rifle, get the shotgun. That was possession, and he brought it back to that property. You also heard him admit in that conversation that he shot that rifle. Oh yeah, I shot the rifle, shot dogs. I did that. Does it stand to reason that he didn't know about that shotgun? For the statement or the phrase "in for a penny, in for a pound," right? If you're admitting to, yeah, I knew about the rifle, but didn't know about the shotgun. That's not logical. And if we go into that logic piece, when Ms. Prater testified that she is the one who went out and picked up that illegal weapon and a TV and brought it back to her home. And she placed it inside her home, in the freezer inside her home. But lo and behold, you've seen State's Exhibits 4 and 5. Let me clarify that. State's Exhibits 2 and 3. The interior of a freezer. Not working. But where was that freezer located? Outside. Not inside, as Ms. Prater testified. Reminds me of that story about if you're walking down a country road and you're noticing all the fence posts on your right side, you come upon a turtle popped up on the top of that post. That turtle logically climb itself up that wood, prop itself on that pole, or did somebody put it there? I submit to you, somebody put it there. That's what logic would tell you. Nothing magical happened. Gravity didn't fail to exist, and the turtle floated up and lightly tapped down on that post. Somebody put it there. Submit to you that Reginald Young went and grabbed that shotgun, went and grabbed that rifle, and put them there. The other photograph showing the rifle is inside, in the living area of that trailer. State's Exhibit 5 and 4. Ms. Prater readily testified and said, yes, that's the inside of my trailer. That's where I live. I've never seen that before. To her credit, she wasn't there on the 25th. I submit to you that those weapons were there for a while. Mr. Young brought them over and you about them. By definition, that is a prohibited weapon. It's easy, I've pointed out to you in terms of the 11 inches, the less than 26 inches. And by all accounts, are you going to believe what Mr. Young told you through that interview with Agent Petrie and Investigator Kellner? He knew about the guns, he had fired the rifle. Or are we gonna rely on Ms. Prater's testimony that she was responsible for moving those weapons over, but yet she doesn't know what happened on November 25th, 2020, Van Zandt County, state of Texas? Entirely, every bit of evidence points to the day we were, Mr. Young, and I'd ask you to return that. Thank you.
Thank you, Mr. Hernandez. Stevens.
I'd like the podium, Your Honor. May please the court, counsel. Good morning, ladies and gentlemen. Again, I want to thank y'all for being here. Y'all are serving a very, very important function, important duty for our society as it is. So I do want to thank each and one of y'all for being here. I want to point out that my client chose not to testify. It's his Fifth Amendment right, just like it's each of y'all's Fifth Amendment right to not testify if you were ever in his position. So you cannot hold that against him, ladies and gentlemen, that he did not testify. Let's don't get confused with the shotgun and the rifle. I believe the rifle's coming up to be kind of a scare tactic, so to speak. The issue is about the shotgun. It's not about the rifle. It doesn't matter if my client had fired the rifle or not. The issue is the shotgun. You know, we did hear from Ms. Prater. She had no reason to get up here and lie. I realize she's testifying to help her son. However, she has no reason to get up here and lie, ladies and gentlemen, because she has perhaps put herself in a position of compromise. I could very well file a case against Ms. Prater because of her testimony about stating that she is the one that handled the firearm, not her son. So she had a lot on the line when she got up and testified, ladies and gentlemen. And, you know, if y'all listen back to the recording from Agent Petrie, if you recall, my client at the very beginning said he did not put the shotgun in the freezer, that his mom did. And then after they talk a little bit more, Petrie basically, in a way, threatened my client, hey, you better tell the truth, okay? And then at that time, he says, well, yeah, I did it. He didn't want to get his mom in trouble. That's obvious. You know, he loves his mom. He doesn't want his mom to get in trouble for anything. So, okay, I did it. That's what he said. And ladies and gentlemen, a lot's being made about this possession, as well as it should be, you know. And if you ladies and gentlemen would go look at when y'all get the instructions again, look at where it says about possession, ladies and gentlemen. Care, custody, control, and management. I disagree with the prosecutor when he grabbed the shotgun a while ago and then laid it back down. He said he still possessed it. I guess if I go touch it, then I'll possess it. Doesn't make sense, ladies and gentlemen, okay? My client did not live at that location, period. His mom testified he lived in Athens. If my client had gone to get the shotgun and the TV, why would he have taken it to his mom's trailer? Why wouldn't he have taken it home to his house in Athens? Just doesn't make sense, ladies and gentlemen. And if you look at the shotgun, I mean, I realize under the definition of the law, it might be a prohibited weapon, but it's more of a relic than anything else. And if somebody grabbed it It's not operable. You can't even fire the thing. Now, we've heard talk about, oh, you could put a firing pin in it. Yeah, if somebody knows what they're doing. But come on, it's not, it's more of a relic or an antique than anything else, ladies and gentlemen. And also, ladies and gentlemen, kind of show the fact that my client didn't live at that location. When the deputies came from Smith County, they were investigating a burglary that happened in Smith County. Some of their investigations led them to this location. When they get there, my client's asleep in his truck or his car. If that's his home, why wouldn't he be inside the mobile home or the travel trailer sleep? Why would he sleep in his vehicle? He would have been in the house. He didn't live there, ladies and gentlemen. He did not live there. His mom lived there. He was merely going over there to take care of the animals and whatnot when his mom was out of town. I'm sure mom doesn't know, but I'm sure he was going back and forth and basically on a daily basis taking care of the property. Ladies and gentlemen, there is reasonable doubt in this case. Absolutely. There's reasonable doubt as to who put the shotgun in the freezer. Let's just say my client did put the shotgun in the freezer for a moment. Okay. He doesn't live there. He doesn't have care of control of it once he left that building. No. But he didn't put it there, ladies and gentlemen. His mom did. And she put her neck on the line when she got up here and testified. And she testified to the truth, ladies and gentlemen. She did. You can look at her demeanor. She wasn't combative and, she was confused about the 22. She wasn't familiar with the 22. She's not familiar with any weapons for that matter. She never fired a gun, period. So, ladies and gentlemen, I'm going to ask you to find my client not guilty. Again, listen to the video. Listen for the reason why my client changed his story to the agent. Check that out. And again, ladies and gentlemen, my client did not have care, custody, control, or management of that weapon. Again, thank y'all for your close attention to this case, and I really do appreciate y'all being here.
Thank you, Mr. Stevens. Mr. Harwell.
Thank you, Your Honor. Morning, ladies and gentlemen. So I want to start by just addressing a couple of things that Mr. Stevens brought up. The first being whether if he had grabbed the shotgun, whether he would be in possession of it too. And under the law, yes. Actually, everybody who has the ability to control, manage, or take custody of that shotgun is in possession. Possession is not limited to one person. Multiple people can be in possession of the same thing. If any of you have spouses or significant others own a car together, you're both in possession of the car because you both have the ability to manage it, control it, take custody of it. So I submit to you that, yeah, more than one person can be in possession of the same thing at the same time. Next, I want to talk about Ms. Prater's testimony. Mr. Hernandez asked several times, your testimony today is that you put the shotgun in the fridge inside the RV. Yes. Not in the freezer outside. No. So how did it get there? Somebody must have moved it. Not Ms. Prater. She testified to that. She told you unequivocally that she did not move that shotgun to the freezer. Logically, somebody had to have. And next I want to address Agent Petrie's. You heard his testimony that he had no interest in charging Ms. Prater. And you heard it during the conversation. Look, I know your mom's not a bad person, and I have no interest in charging her. I only want the truth.
You heard his testimony, you heard him. He had no interest. Is he waiting out in the hallway to arrest her? I highly doubt it, even with sworn testimony. So I want to talk more about the evidence in the case. So on or about November 25th of 2020, we know that that was the date that Mr. Young was arrested for this offense. We don't know exactly what day he moved that shotgun around, but that's why the law allows for on or about. We know that he did it. Could have been on the 25th, could have been within a few days of the 25th. And we know that he was managing that property. Testimony today was that Mr. Young was taking care of the property. Well, what is taking care of if it's not managing? And he did in fact know that the shotgun was there. You heard in that conversation, he knew quite a bit about the shotgun. Told you that he had a cousin inspect the shotgun. So he knew it was there. You also heard in that conversation that, yeah, he did in fact go and pick up that shotgun. Once Agent Petrie told him, look, I'm not after charging your mom, I just want the truth. Yeah, I went, I picked up the shotgun and the 22. You heard testimony that it was in Van Zandt County. That's undisputed here. It's in properties in Ben Wheeler. This is in Van Zandt County. Everybody agrees that Mr. Young is the person in question. There is no question as to who we're dealing with here. And so I want to go into a little bit more about the intentionally and knowingly. So you heard about the firing pin. You also heard just how easy it is to slip a firing pin in. You heard Agent Petrie talk about just how many firing pins there are and how readily available they would be to get to make that shotgun fully operational in a matter of moments. You heard Agent Petrie talk about why it's important for this law. He told you how the law came about with mobsters hiding them under trench coats, how they're easily one-handed weapons that can be hidden from anybody. And he also talked about the fact that the nature of a weapon doesn't change with or without a shot, with or without a firing pin. If that shotgun was pointed at you, I doubt that any of you would think, does that have a firing pin? Still a weapon. And that's why it doesn't matter whether the firing pin is in it or not. It is still a weapon by the very nature that it is designed to expel a projectile. You heard Agent Petrie talk about the fact that it's not an antique. That fires a shotgun shell, a 16 gauge shotgun shell. He told you that a antique weapon is a black powder rifle, a muzzleloader. For those of you not familiar, that's a single shot, like you see in a Civil War or Revolutionary War, that long process of pouring powder down the barrel, putting the slug in. That's an antique weapon, not that. And I want to talk a little bit about this 22 and why it's important. It's important because it corroborates everything else. Because you heard in the conversation, Mr. Young talked about, yeah, I fired the 22. If there were dogs getting into the trash, I'd have to shoot at them, have to get rid of varmints, shoot it just for fun. We live in the countryside. Hey, nobody can blame you. I mean, 22s are fun to plink with. Anybody who's ever gone out plinking with a 22 knows that, hey, quick way to blow off a little bit of stress, right? So why is it corroboration? Well, because he told you that the 22 and that sawed-off shotgun were together. So it's further indication that he did know about the sawed-off shotgun. When Agent Petrie asks about his fingerprints, that's when he starts to hesitate, because you'll notice that in that conversation, Mr. Young was only concerned about that shotgun. From the very beginning, how can I be charged with a weapon without a firing pin? It's the only thing he was concerned about. So he equivocated. I don't think my fingerprints are going to be on that shotgun. I highly doubt they'd be on that shotgun, but he can't give a definite answer because he's hoping that they're not on the shotgun. But he can't say that they're not because he knows that he did in fact move that shotgun. That's why he couldn't give a definite answer. And yeah, you heard from Agent Petrie, who told you that, yeah, with a gun like that, wood grain, some rust on it. There's nothing for a latent print to stick to. So yeah, we could not have pulled a fingerprint from that if we tried. Next, I want to talk about a specific thing in the indictment. And that's that this is an Eastern Arms shotgun, a 16 gauge. Well, you've heard testimony that this isn't in fact a 16 gauge. You heard that in that conversation. And I want to point out to you, it's extremely faint. But Eastern Arms, you probably can't see it from there. I'd be surprised if you could. It is extremely faint, but Eastern Arms is written on the side of this firearm. So this is in fact an Eastern Arms 16 gauge shotgun. Ladies and gentlemen, during Verdire, Ms. Curry talked to you about the law in this case. Talked to you about firearms. Talked to you about whether, if you believe the evidence, whether you could convict. And each of you, by your answers, indicated that you could. If you believe this evidence, you indicated that you could convict. And then the judge puts you under oath to uphold the law. Ladies and gentlemen, what I'm asking you is to hold you to your oath. That if you believe this evidence, which is clear, that you convict Mr. Young of this offense. Because on or about November 25th, 2020 in Van Zandt County, Reginald Hoyt Young II did in fact possess a prohibited weapon. Thank you.
Thank you, Mr. Earl. All right, ladies and gentlemen, at this time, you have received the court's charge, all of the evidence, and the closing argument of counsel. I'm going to hand to Deputy Martinez the official instructions of the court. He's going to deliver those to you. When you all gather into the jury room, it will be time to begin your deliberations, all right? So all rise for the jury. All right, we are on record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. Court has received a message that the jury has reached a verdict. Any reason we shouldn't bring the jury in at this time and receive the verdict?
None from the station.
No reason. Okay. All right, let's all rise for the jury, and I'm going to have the alternate juror brought in as well. Turn in. Yes. Do that velvet vote. Yes. Thank you, sir. Give it all. Thank you. Come down the middle. All right, thank you. Maybe see. Let the record reflect that the jury is now present and seated along with attorneys for the state, attorney for the defendant, and the defendant. It is my understanding that the jury has reached a verdict. Who is the foreperson of the jury? You have the notebook in which, there we go. Give that to Deputy Martinez. I'm going to inspect the verdict, and then I'm going to return it to you for reading. All right, court's returning this to the foreperson. Mr. Young, if you will please rise. Madam foreperson, if you will rise, if you will present the verdict of the jury to the defendant at this time.
We, the jury, find the defendant, Reginald Hoyt Young II, guilty of possessing a prohibited weapon as charged in the indictment.
Thank you. You may be seated. Mr. Stevens, would you like to have the jury polled?
No, Your Honor.
All right. There being no request for the jury to be polled, the court finds that the verdict is complete and it is the unanimous verdict of the jury. All right, so the defendant having been found guilty, court will then proceed to the second phase of trial, the punishment phase, with the state like opening statements at this time.
Your Honor, may we approach this briefly?
You may. All right, ladies and gentlemen, there's been a request to recess for a bit. Since we have just had our lunch recess, I'm gonna go ahead and allow the attorneys time to get their things in order for the punishment phase of trial. So it is 1 o'clock. I'm gonna ask that you be reassembled in the jury room. You're not gonna be required to stay in the jury room if you want to separate. You've not received all of the evidence on punishment or the court's instructions or closing arguments, so you're not to be discussing the case amongst each other regarding the punishment phase of trial. Okay, so make sure that you're back in the jury room no later than 1:30. All rise for the jury. You'll kind of go right back to the same thing you were doing. Yes, you will. All right, court's in recess till 1:30.
Thank you, sir.
We are on record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Attorneys for the state, attorney for the defendant, and the defendant are present and seated. The court previously took a recess at the request of counsel before we began the punishment phase. It's my understanding that there's a proposition from counsel. Is that correct?
Yes, Your Honor. State has agreed to resolve the case for 20 years and to 1245, the new arrest charges from a couple weekends back on manufacture, delivery of controlled substance, and evading, and a forgery.
Okay. Mr. Stevens, any response?
Yes, Your Honor, that is our agreement. And so with that being said, at this time, we would withdraw our request for the jury to do punishment and ask them to be changed to the court to do punishment.
Okay.
And Your Honor, I'm sorry, just to make sure I'm complete with the offer, that's also to waive appeal on the case.
That is correct, Your Honor.
All right, so what I want to do is take Mr. Young, I'm going to take him under oath, and then I want you to ask those questions to make sure that he's clear on what his rights are and what he'd be waiving today. Mr. Young, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today for this limited purpose will be the truth, the whole truth, and nothing but the truth, so help you God? All right, go ahead, Mr. Stevens.
Please state your
My name is Reginald Hoyt Young II.
name. Yeah, we have a jury trial. All we got.
Perfect, thank you.
All right. We just completed jury trial, correct?
Yes, sir.
You were found guilty.
Yes, sir.
Okay. You also have 3 other charges pending at this time.
I do.
One would be a first degree felony and the others would, I'm not sure what level they are, but first degree felony on the first one, right?
Yes, sir.
Okay. Now, the deal that's been made today is for you to waive your appeal, accept a 20-year offer, okay, to wrap up everything.
Yes, sir.
In other words, the new cases will be what's called 1245. What that means is the state knows about it, the judge knows about it, you know about them, you're admitting that you know about them, and then they get dismissed.
Yes.
Okay. Is that your intention? Is that what you want to do?
Yes, sir. That's what I want to do.
Pass the witness, Your Honor.
And Mr. Young, has anybody threatened you, forced you, or pressured you to make that decision here
Yes, sir.
today?
I have.
And you understand, Mr. Young, that the state of Texas, I'm assuming, does not have a lab report back on any of the newer charges that have been referenced to by Mr. Stevens. So the amount could come back that makes it perhaps a second degree or a third degree. You understand that?
I understand.
Understand that. And you've considered all of that and you've had the advice of your attorney, Mr. Stevens, and you're telling me today that you understand all of those potential risks, that you're waiving your right to be indicted on those cases. You're waiving your right to have a jury, and you're asking the court to accept the 20-year recommendation of the 20-year prison recommendation of the state of Texas and waiver of your right to appeal in this case in which the jury has found you guilty for possessing a prohibited weapon, to take the other unfiled cases in consideration, meaning that you would not be prosecuted of those offenses in the future.
I do.
Do you have any questions or any concerns that we need to address before we go further?
I would just like to make sure that all of my back time that I have applied on this case, since I caught this case that I'm here for today, the prohibited weapon case on November 25th, 2020. I would like to make sure that all my back time that I have accumulated over these last 4 years is credited to my sentence. As long as that's credited to my sentence, I have no objection to anything. I'm ready to get it over with.
And the law does require the court to give you credit for any time that you've spent in jail on this charge prior to trial. Now, I know that you have been out on bond several times on this case. You understand?
So I have.
And so the only time that you're going to be credited for as back time is actual time spent in jail on this cause.
Yes, sir.
Does the state have any idea what that may be?
Not yet, Your Honor. We haven't started looking back to get the calculation started on it.
Okay. And so, Mr. Young, do you have an idea of what that might be?
I'm thinking roughly about 16 months, about 15 to 16 months over the past 4 years that I've been arrested on this prohibited weapons charge that I've spent incarcerated in jail.
And we can verify that. Let me ask you, Mr. Young, if your recollection is different than what the data shows, is that going to have a bearing on your decision today as to whether or not you accept their offer?
Well, I would like to know. I would like to know where it is, because I mean, as far as I know, every time I've been arrested and I've been on I've been arrested. Every time I've been arrested, it's been for this charge, and the bond has been, every time I've been arrested, the bond has been dropped, and I've had to make bond on it again. So I would like to know. Yes, sir. Most definitely.
Okay, prior to you entering into an agreement?
Yes, sir. If I could.
Yes.
Yes, sir.
Yeah, I think we can make that work.
All right.
And let me, hang on, I'm sorry, Mr. Hartwell, let me ask one more question before I forget. And so, Mr. Young, you understand that if we verify your credit time and it is acceptable to you based on what time you actually spent in jail, if you change your election for the court to assess punishment and to accept this recommendation, this agreement between you and the state, you understand that you can't change your mind later once I let the jury go.
Yes, sir.
You understand that there's a jury right behind that door and they're ready and willing to come out here and hear the evidence and give a verdict on that. And that range of punishment, to my understanding, potentially is from a minimum 2 years up to a maximum of 20 years based on an enhancement allegation that's been filed by the state. Understanding that if I accept your recommendation and your agreement, and I'm telling you that I would, okay, I'm not telling you that it's a if, I'm telling you that the agreement as you stated it, I would accept that. But once I inform the jury that they're free to, can't later change your mind and say, hey, I want a new jury or I want that same jury back. That would be over and done with. You do
Well,
understand that?
I do understand that, Judge, because one thing I understand is, no matter what, I understand with the punishment phase, I know it can go anywhere from 2 to 20 years anyway. So for me to have new charges that I have to face anyway, it's better for me to go on and just take what I'm getting and get everything behind me to where I can get it finished and get on with my life, man, to try to do something different. You know what I'm saying?
I understand. And
Yes.
so to me, Mr. Young, it seems that you have intelligently thought through this offer and the decision you're making is based on potential risks that you could be facing in the future.
Yes.
Okay. All right. So let's do this. Were you going to say something, Mr. Earl?
Just a quick question, Your Honor, to make sure that Ms. Abney is looking everywhere for jail credit. Was there any incarceration time outside Van Zandt County?
There was some in Henderson County. There was some, but I was arrested on the Van Zandt. I was arrested on the charge in Henderson County, and whenever I was arrested on the charge in Henderson County, that was also a part of my. Whenever I was arrested on the charge in Henderson County, that was also a part of my. The reason I was arrested was because I had the warrant out of Van Zandt County, so I was arrested in Henderson County for something else, and I was there, locked up there the whole time, and then it was just all part of it. So after I got done with my time in Henderson County, I was brought back to Van Zandt County. This was last year. I was brought back to Van Zandt County and my bond was reset and I had to bond out on this prohibited weapon thing again. But as far as it goes, whenever I got stopped in Henderson County last year and I went to jail for the time that I was there, I was stopped and I was taken in to custody for my warrant that I had active out of Van Zandt County for prohibited weapon charge.
Okay, so I'll have Ms. Abney look at Henderson County as well as Van Zandt County for that.
Any other counties?
And I had a little bit, I had a misdemeanor charge out of Smith County that I had to go to at the same time to sit out at the same time. But I was only there like a week, maybe a week and a half, 2 weeks that I was in Smith County, but I was in, I had for all three counties. I had a prohibited weapon here. I had a misdemeanor marijuana charge out of, Smith County, and I had the new charge that I had in Henderson County that I had obtained whenever I had the warrant.
Do you believe when you were serving time in Smith County for that warrant or for that, you say misdemeanor marijuana?
Yes, they arraigned me whenever I was there. The day that they brought me there to Smith County, they arraigned the morning that I got there that Henderson County transported me. They arraigned me in Smith County on the prohibited weapons charge there.
So potentially you have credit time in Van Zandt, Henderson and Smith?
Yes,
Okay. All right, then what we'll do is we'll stand in recess. I'll have Deputy Martinez let the jury know that we're dealing with some legal issues. And then if we can go ahead and try to get a back time verification for Mr. Young, then once we get that, if you'll go ahead and communicate that to Mr. Stevens. And then if that's gonna be acceptable and appropriate, and we feel like that is accurate, then we'll go on to the next step.
all right.
Yes.
Thank you.
All right, court will be in recess. All right, we are back on record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of a jury. Attorneys for the state, attorney for the defendant are present and seated. All right, some understanding that the back time credit for Mr. Young has been confirmed. Is that correct, Mr. Hartwell?
Yes, Your Honor, confirmed at 329 days.
All right, Mr. Stevens, did you convey that to Mr. Young?
I have, Your Honor.
And that's not as much as what I believe Mr. Young thought at the outset.
Right.
Does that in any way affect his decision on whether or not to accept the agreement from the state?
No, sir.
All right, so Mr. Young, I've already placed you under oath earlier to tell the truth, so you're still under oath. So Mr. Young, you understand now that your back time credit is 329 days.
Yes, I do.
In understanding that, do you still wish to go forward with your plea?
So,
Okay, all right, so the paperwork's being written up by the state right now. And so we'll go over all of that later. At this time, you are changing your election for punishment to be assessed to the court instead of the jury. Is that
yes,
correct?
yes, sir.
And you understand that I'm gonna bring the jury in, I'm gonna release them and let them go. And once that's done,
It's over
then
with.
it's over with. You understand that? Okay, and so you're positive that this is the decision that you want to make?
Let's get it.
Okay, all right, then let's all rise for the jury. All right, thank you. Maybe see them. All right, ladies and gentlemen, at this time, I do want to inform you that your duty as jurors is going to come to an end. Mr. Young has elected to change his punishment election to have the court assess punishment instead of the jury. So this time, all of the instructions that I've given you previously about not discussing the case with anyone else, you are released from that instruction. You're free to speak to whomever you want to about the case. You're also free not to. So just on behalf of Van Zandt County, attorneys for the state, attorney for the defendant, we do appreciate you and your willingness to serve. I'm going to ask that you assemble into the jury room and give me just a few moments. I'll answer any questions you have. And I do want to give you an opportunity to give some feedback to the court on the jury process, okay? After which the attorneys for the state, attorney for the defendant may wish to speak with you about the case to get your impressions of the evidence, make sure there was no jury misconduct, and to get any kind of insight that may be helpful for them in their practice, okay? At that time, when the attorneys come in, you're welcome to stay and talk with them. You're also free to go, all right? So if you will, just give me a few minutes in the jury room. Let's all rise for the jury. All right, we are back on record in cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. The record has already been made that the jury has been discharged and released upon Mr. Young's changing his election for the court to assess punishment rather than the jury. The court finding that Mr. Young, having entered into an agreement with the state of Texas, finds that the recommendation as to sentencing from the state and the defense is for upon the court, which it has already accepted the jury's finding of guilty on the charge of third-degree possessing a prohibited weapon, finds that the range of punishment is not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court, taking judicial notice of all filings in cause number CR 2198, including the indictment, finds that an enhancement paragraph has been alleged in the indictment and alleging that Mr. Young, having been convicted of a prior felony once before would enhance the range of punishment from that of a third-degree felony to that of a second-degree felony under the statute, oftentimes known as repeat felony offender. So, Mr. Young, I would ask you, you've reviewed the indictment with your attorney, Mr. Stevens, is that correct?
Yes.
And you've reviewed that enhancement paragraph wherein the state has alleged in the indictment that on or about June 20th, 2013, in cause number CR 09-493 in the 294th Judicial District Court of Van Zandt County, that is this court, that you were convicted of the felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams. According to that accusation, is that accusation true or not true?
That's true.
That is true. And Mr. Young, has anybody threatened, forced, or pressured you to plead true to that enhancement?
No, they haven't.
All right. Court does accept the defendant's plea of true. Court finds that Mr. Young is enhanced up to a second-degree felony range of punishment, not less than 2 years or more than 20 years. Court finds that enhancement paragraph to be true. Court finds that the recommended sentence and the agreed sentence recommendation from both the state of Texas and the defendant in this case is for Mr. Young to be confined for a period of 20 years in the Texas Department of Criminal Justice Institutional Division with court costs of $290, reimbursement fees of $255, and jail time credit of 329 days. The court hereby follows the agreement and the recommendation, and the court assesses punishment at confinement in the Texas Department of Criminal Justice for a period of 20 years, orders court cost and reimbursement fees, and awards Mr. Young his jail time credit for the time that he has spent in jail on this cause. Mr. Hartwell, I believe that you said that there was also some disposition letters that you are submitting to the court at this time to show that some other allegations in which Mr. Young has been accused but not officially charged by indictment or information. Is that correct?
Yes, Your Honor. State wanted those disposition letters to be part of this record.
All right, the court finds that 3 disposition letters from the Van Zandt County Criminal District Attorney's Office have been submitted. The court finds that the state is asking the court to take into consideration and to dismiss and prevent Mr. Young from being prosecuted on forward. It is a manufactured delivery of a controlled substance greater than or equal to 4 grams, less than 200 grams. Date of offense on or about October 26, 2024. The court takes that into consideration. Agency case number 24-29782 of the Van Zandt County Sheriff's Office. Prosecution number DA 2024-1102. Court also takes into consideration an evading arrest or detention with a vehicle or watercraft, a third-degree felony, on or about date of offense on or about October 26, 2024. Van Zandt County Sheriff's Office number 24-29-29782. DA cause number DA 2024-1103. The court takes that offense into consideration and bars prosecution pursuant to this sentence. Court also takes into consideration under section 1245 with the sentence in this cause a forgery of a financial instrument, date of offense alleged on or about October 26, 2024. Van Zandt County Sheriff's Office, agency case number 20868, DA prosecution number DA 2024-1104. Court takes that into consideration at this time too. Court also finds that the defendant in this case has waived his right to appeal. Board is signing the certification of defendant's right to appeal. And also the Michael Moore Court notes the receipt of the Michael Moore certificate of discovery. All right, Mr. Young, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez here. Thanks, sir. I'll get copies for the jail. I'll send that with you, Deputy Hosmer. All right, Mr. Stevens, is there anything further on behalf of your client, Mr. Young?
No, Your Honor.
Anything further from the state?
Nothing further, Your Honor. Thank you.
All right, if there's nothing further, then we are adjourned in this case. I will get you paperwork right now.
I get a copy of that too?
Yes, sir. I'll get you a copy of everything.
Thank you. Yeah. Yeah, I like it. Whenever you send me that, you send me who I need to too as far as.